Introducing the all-new Corolla.
Acting Judiciary Staff Attorney Jerry Cepeda advised the Judicial Council today to hold off on implementing the Hay pay increases as submitted by the governor to the legislature. She says the way the law is written makes it so that the way the governor chose to implement the Competitive Wage Act is unlawful. She cites 3 different points in her legal opinion, all of which conclude the same thing. One section,
Section 2E, provides that the plan would be effective unless disapproved or amended. I submitted in my opinion that by virtue of Bill 268-32, the legislature actually submitted an amended plan, which in effect extinguished the ability of the administration to have the plan automatically be accepted within 30 days.
And in another section, Section 2B, she says requires that the legislature approve the plan. If it fails to act on the plan, then it is automatically implemented within 30 days of submission by the governor.
That part of the statute seems clear that approval would be required. However, when interpreted next to or attempted to be reconciled with subsection 2E, which states that the plan would be effective within 30 days, creates what I believe is a conflict and internal inconsistency in the statute that renders it unable to be effectively implemented.
Governor Eddie Calvo submitted his plan to the legislature on January 15th, but the legislature introduced a measure, a revised version of the Hay Plan. That bill was passed by the legislature but vetoed by the governor. Cepeda says there is no clearer demonstration of the ambiguity of the situation than this.
It's not precisely stated and has never been specifically articulated by the administration. However, from its actions, it appears that the administration is relying on subsection 2E, and the fact that there seems to be an automatic or presumptive approval of the plan that is submitted to the Guam legislature, and which was subsequently submitted on January 15th.
Cepeda points out because the executive branch chose to implement the plan regardless of legislative action, it chose to unilaterally amend the law, which it does not have the authority to do without legislative approval.
It's difficult to reconcile the existing law. The only way that it would work is for the DOA plan essentially to supplant what is current in the law. In that case, that's definitely that's interpreting this as a delegation of authority, a delegation of its authority to legislate. A unilateral action by the executive branch cannot supplant the legislative authority to amend or to repeal existing law, which in essence would happen if you were to interpret the DOA plan as the valid method for paying government of Guam employees. Interpreting the plan harmoniously with the statutes would and could only result in an impermissible delegation.
Just want to make clear from legal counsel, just what is it you're recommending the Judicial Council how we proceed?
Yeah, yes, I should have led with that. My recommendation is not to implement until there is further guidance regarding the issues that I've raised.
Chief Justice Robert Torres and Justices Philip Carbolito and Catherine Merriman also wanted to make it clear that they were not taking a legal position in Cepeda's interpretation of the law, only that they are deferring implementation to allow acting administrator of the courts, Josh Tenorio, to seek further guidance from the legislature on whether or not they believe the governor's Hay Plan is legal.